You have to go 4 for 4. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. 4 for 4? What in the heck are you talking about, Jim Hacking? Here's what I mean. When you receive a request for evidence, or when you receive a notice of intent to deny your immigration case, they are going to ask you for certain things. Might be 2 things, might be 3 things, might be 7 things. However many things they ask you for, you have to go 4 for 4 or 5 for 5 or 6 for 6. What do you mean by that, Jim? Well, sometimes these requests for evidence or these notices of intent to deny are really confusing. They pour in a bunch of extra language and things that don't really apply to your situation. They might cite the statute, they might cite the regulation, but at the end of the day, they're asking you for things. And I've heard too many people and I've talked to too many souls who have not provided everything that's contained in the request for evidence or everything that is noted in the notice of intent to deny. And so when you receive an RFE and when you receive a notice of intent to deny, you have to go through it line by line, and you have to do it and figure out what exactly are they asking me for. And then you have to get them all of those things. If you only get them 3 out of 4 or 5 out of 6 or 3 out of 7, your case will be denied. This is sort of like in school. You have to answer every question. You have to provide everything that's requested. If you don't apply all of it, if you don't submit all of it, it's going to be very, very easy for them to deny your case. So I want to make sure that you understand when you receive that request for evidence, it's because something is wrong with your case. It's because they're this close to denying your case. They're this close to making you file all over again, to file those fees, to pay all that fees and wait all that time to get the immigration benefit that you're trying to get. Your case, if you receive a request for evidence, and especially if you receive a notice of intent to deny, is for all intents and purposes on life support. It's this close to being denied, and you've got to take it very, very seriously. And I want you to understand that you have to get everything right. You have to get everything submitted. It is your one chance, because if you give them a clean, easy way to deny the case, they're going to do that as opposed to having to analyze what you already sent in. So I have seen situations where people have sent an overwhelming amount of evidence in response to issues 1, 2, 3, and 5, and just barely sent in anything for issue number 4. That is something you don't want to do. If you do that, they will not spend time trying to figure out if you satisfied the requirement under number 1, under number 2, under number 3. They're simply going to say, we asked you for 1, 2, 3, 4, and 5, and you didn't give us 4, so therefore your case is denied. This is a big problem. You need to be very thorough. And so I think that if you have received a request for evidence, or if you've received a notice of intent to deny, and if it is asking for something more than your medical exam, for instance, if it's asking for information related to your affidavit of support, or more ominously, if they're asking for greater marital evidence, this means that they are not convinced that your marriage is legitimate, or they're not convinced that they want to approve your case. So if you find yourself in that situation, you need to think long and hard about hiring an attorney to try to get you over the goal line, to try to analyze this request for evidence and let you know exactly what they are asking for. Because, like I said, if you miss one thing, your case will be denied. So you got to go 4 out of 4. You got to go 5 out of 5. You have to give them every single thing that they ask for, or you're going back to the end of the line, you're losing all your filing fees, and most importantly, you're going to have that black mark of a prior denial on your immigration record. And that, my friends, is what you don't want. If you did receive a request for evidence, or if you did receive a notice of intent to deny, or if more importantly, you want to file the strongest case possible so that you hopefully don't get a request for evidence or don't get annoyed, then you should call our office, 314-961-8200. Email us, info@hackingimmigrationlaw.com. If you're just looking for free information or wanting to find out what other people going through the immigration process are experiencing, join us in our Facebook group. It's called Immigrant Home. You can join for free. There's thousands of immigrants in there talking about the immigration process every single day. We also have our YouTube channel where we have thousands of videos of me explaining different immigration concepts. It also has the back 400 plus episodes of the Immigration Answer Show, which is simply me answering immigrants' questions about the immigration process. If you want to join us on that show, you should text the word show to 314-470-3300, and you'll get an alert when we're going to go live. You'll have access to our waiting room so that you can get in there before the show starts and ask us your immigration law related questions. Thanks so much for watching. We'll see you next time.